आज आपण ड्रीम्स रिडेव्हलपचा पहिला वेबिनार आपण रेकॉर्ड करतोय आणि आम्हाला खूप हे होतं की कोणाला बोलवायचं पहिल्या रेकॉर्डिंगला वगैरे. तर आम्हाला वाटलं की सगळ्यात मोठा रिडेव्हलपमेंट मध्ये सगळ्यात मोठा मुद्दा लीगलचा असतो, म्हणून आम्ही पहिला जे लोकांना म्हणजे इंट्रोड्यूस करायची गरज नाहीये. खुर्जेकर सरांना आम्ही अप्रोच झालो आणि खुर्जेकर सर आनंदाने बोलले की नाही आम्ही रेकॉर्डिंग करूया आणि जे लोकांना मार्गदर्शन लागतं त्या या वेबिनार माध्यमातनं आणि जे काही मेजर प्रश्न असतात ते एक एक करून सर सोडवत जातील. तर आमच्याकडे सोसायटीकडनं खूप प्रश्न येतात, तर ते प्रश्न आम्ही सरांना दिलेले आणि ते सर एक एक करून आपल्या मार्गदर्शन करतील की या सिच्युएशन मध्ये किंवा कुठले रेग्युलेशन अप्लाय होतात आणि सोसायटी असेल आणि अपार्टमेंट असेल तर त्यांनी काय मार्ग घ्यायचं. कारण जनरली लिगली जेव्हा रिडेव्हलपमेंट मध्ये लोक अडकतात तर ते रिडेव्हलपमेंट थोडं लांबतं किंवा स्थगित होतं. तर हे या वेबिनारचा मेजर उद्देश आहे. तर थँक्यू खोजेकर सर, तुम्ही आमच्यासाठी वेळात वेळ काढून दिला. सर जनरली बिझी असतात पण त्याच्यातला वेळ काढला. तर आपण सुरुवात करूया. तर पहिला सर मेजरली एकदम बेसिक प्रश्न, जेव्हा एक सोसायटी किंवा एक अपार्टमेंट रिडेव्हलपमेंटला जाते तेव्हा त्यांना कुठले कुठले रेग्युलेशन अप्लाय होतात आणि त्यांनी जर कोणाला जर अभ्यास करायचा असेल तर कुठले कुठले रेग्युलेशन त्यांनी वाचावं, त्याचं पालन करावं.
Thank you for inviting me over this session. You have given me certain questions which generally you get from the members of the societies or the societies. It is about, the first question is, what regulations are applicable for society and apartment while undergoing redevelopment? For apartment, let me take you first to the apartment. For apartment, there are no such regulations as of now. The government has not considered to frame any regulations as has been framed for the cooperative housing societies, and definitely there are no rules or there are no such guidelines issued by the state government, nor even the honorable courts, rather high court I would say. But for the cooperative societies, yes. Firstly, on 3rd January 2009, the state government has issued certain guidelines that how a redevelopment should, how a society should undertake a redevelopment process. Thereafter, after experiencing the practical difficulties and practical working with those regulations, on 4th of July 2019, the government again issued the modified guidelines. From that guidelines, it is generally, as if now at least we practice in Pune, we generally observe the similar line of the guidelines for redevelopment of apartment also, because it gives the transparency, and what is most important thing in the redevelopment is transparency. Further, the trust between the members either of the society or of the apartment. So when the transparency and trust is important and it has been transpired in the those guidelines issued by the state government, it is always easier for apartment also and society also to follow that those guidelines. Definitely, whether those guidelines are mandatory, there is judgment of Honorable Mumbai High Court that these guidelines are not mandatory, but those are in directives in sense, gives a route or a path for the members, the society and the builder also, to how to redevelop the society, how a person or a member should not get suffered by certain might be office bearers of the society, might be the builder, or might be other members also. Definitely, after coming into the force of the RERA Act, the entire vision of the real estate business has been changed. You might be more aware than me. So those particular provisions of RERA also can be made applicable, but that is apart. That is something while we are moving to the redevelopment process. But while entering into the redevelopment shoes, we should undergo with the guidelines issued by the state government dated 4th of July 2019, which are easily available on the website of Cooperative Department. Should I take the next one?
Yeah. So if you can also throw some light on which of the points are really critical from the redevelopment guideline dated 4th July, because I think many people are aware about the 4th July, but thanks for clarifying that while it is not mandatory, but it's a directive which people need to follow. So if you can take through salient legal points, what all need to be followed for a redevelopment, that will be really useful.
First of all, there a consensus of the member or of the members is more important. All the members or majority of the members should be ready for the redevelopment. The consensus. Thereafter, uh, either project management consultancy or the architect should be appointed by the society. Before that, a redevelopment committee should be appointed by the society who will take the decisions fast, little fast. So either architect or project management consultancy, after issuing the tenders, after getting the tenders, the best tender would be accepted by the society. First, the redevelopment committee, then the general body. See, every resolution in respect of the redevelopment should be passed by the general body. If general body authorizes a group of persons, say for example, redevelopment committee, so those persons or that redevelopment committee can do certain things on behalf of the society, but again that committee has to come to general body again. See, we have done XYZ work and this is our report. So kindly take the decision. And every such decision shall be binding on each of the member, each and every of the member of the society. So architect or the project management consultancy, then feasibility report. What is feasibility report? If the society is owning a plot of land, say for 1000 square feet, and construction over it, say for 500 square feet, then how much potential that particular land is having to get constructed? We are going to the market, see, I am having this much of the property, and is any capable builder is available to reconstruct our building? The builder is going to construct more than the flat units, I would say, not flats only. There could be offices also. So, how much builder can construct the more units? Because he is also for the business. He is not here for charity. If you are, say, 10 members are there, builder, or 10 units are there, builder may construct as per the feasibility report. He can construct, or he may construct 15 units, and he can sell 5 units, and he will give you the new constructed, well amenitized unit for you, and he will get the profit over there. So what is the feasibility report? Why the feasibility report is important? For this reason, members will get exact idea how much the society can get additionally, how much each member can get additionally, and thereafter how to proceed with the redevelopment process. After feasibility report is being admitted by the general body meeting, the as per the on the advice of architect or that PMC, the society should prepare a tender document. The tender document should be published in newspaper or website of the society for this purpose. Redevelopment as per the guidelines. The website is also important and mandatory one. The builders will get the tender document from society. They will fill up the tender, submit the tender to the society, and uh, on one fine day, the architect or PMC will prepare, after opening definitely, by following the process, they will prepare comparative chart and what is the best solution for the society, that society will get. And after that, society should select a builder and appoint him for redevelopment. बाकी का process बाद में होता रहेगा.
For everyone. Okay. Sir, now there is a lot of talks about 51% people, if they are okay, we will go for redevelopment and all. But majority of the experiences in the market says that even if one person or a few handful of person, while the majority wants redevelopment, few people can still spoil the whole redevelopment experience or put a bad taste in their mouth. So, one is how to tackle them. Secondly, we also have heard a lot of statements like it is basically the silence of the good people which is actually affecting the redevelopment more, because some people may shout or do something, but I think generally that is one thing. So 51%, how definite is that, and how legally can somebody proceed even if majority wants redevelopment and there are one or two people who are not wanting redevelopment for any reason that they have in their mind?
Basically, we are living in democratic country. So rule of the democracy is what? The majority. Majority always wins. While when the redevelopment concept has been produced firstly in Mumbai and thereafter in Pune and now all over in Maharashtra, we are talking about just Maharashtra right now. Many cases which approach up to the level of the Honorable High Court at the first instance, say around 2012 or 13, there are High Court judgments that minimum 75% majority is required. That is 2/3 majority. In the entire Cooperative Act, except for some resolutions, the simple majority has been quoted. For a policy decision like parking, etc., or policy decision like expelling a member, etc., 2/3 majority has been provided. But otherwise, everywhere simple majority has been provided by the Act, the Cooperative Act, Maharashtra Cooperative Societies Act. While dealing with the matters day by day, it is the latest judgment in respect of the majority. The Honorable High Court has quoted 51% is the simple majority. And as the Cooperative Act has manywhere has stated that simple majority is sufficient, then why should we go for the 2/3 majority or something like that? In the current situation, if 51% members are ready for the redevelopment process and all the things like executing development agreement, power of attorney, वगैरह, let us go ahead. Do not wait to even for 52% of the members are ready, etc. So there is a new concept has been developed, that is 51%. 51% is more than sufficient. I won't wonder in coming future it would be up to 50% also, because it's a need of time. The other part of the question was, if a member or group of members are objecting the process or acting, with due respect to all such members who are doing all these things, they are having their own grudges, their own studies, or their own concepts, which may be right, may not be right. But such persons may object a redevelopment process. Such persons may make an obstacle to such redevelopment process. How they can do it? They won't attend the general body meetings. They won't sign on the MOU first or the DAPA also, Development Agreement and Power of Attorney. Lastly, they won't give the possession to the society. The society won't be in a position to hand over the possession of the entire society to the developer. So developer would not start the redevelopment work by demolishing the existing structure. There are various cases since 2015-16. This particular ideology has developed that if a person, irrespective of that society, has listened his objections, his grievances, his grudges, has done XYZ things. For example, he wants certain things to be incorporated in development agreement, certain conditions to be incorporated in development agreement about anything. I won't take much time. There are many things. Then after even compliance or without compliance of those grudges or those complaints or those queries, if the person is not ready to hand over the possession to the society can file a dispute before the cooperative court. Because in 99% development agreement, it is the duty of the society to hand over the possession of the entire society to the developer. It is not the duty cast upon the member individually. In 99% generally development agreement. So it is the duty of the society to get the premises vacant. And for that purpose, society can approach the cooperative court by filing dispute under section 91 of the MCS Act, requesting the honorable court to direct the opponent to vacate his premises and give the possession. There are many cases that even I have also done all these things personally. In the application for injunction at the very first stage of any suit, we have filed and we have won also, because there is merit. The many of the peoples are ready, rather majority of the people are ready for redevelopment, etc., etc. They have vacated their flat, and this gentleman or this lady is not vacating, and therefore kindly I'll grant him or direct him or her to vacate the premises. And in 99% of the cases, except there are exceptions. In 99% cases, court passes such order. See, if you are also getting whatever the other members are getting, or you will get at par with the other members. If at all anything other than this you are having complaint or the grudges, the dispute will continue in future, and that will be subject to your decision. But let us go ahead with the construction. So it is the society can definitely approach to the cooperative court for possession.
Okay.
You have not asked. Let me tell you at this juncture, in respect of apartment, till the stage of possession, everything can be similar or can be made applicable similar. But for the possession, the apartment or the developer there, in the case of apartment, developer can, because the basic, there is basic difference in the concept of society and apartment. The apartment or the builder can approach to the civil court and not to the cooperative court for getting the possession. Yes, please continue.
So one of the critical uh, process in the whole redevelopment is conduct of a lot of meetings. Okay, so now I'll tell you the problem is that majority of the society people are not uh, conducting meeting on a day-to-day basis like a corporate person can do or a board meeting happens. So I mean there are a lot of conceptions and misconceptions about meeting. For example, how many days notice are to be given, how the meeting should be conducted, and how the recording should happen and all. And the fact is that not everyone is a professional who becomes a secretary or a chairman. It's a voluntarily job which they have time and they feel passionate.
They are not even expected.
Yeah, it's not even expected. But I mean, majority of the times when some people who are not willing to go for redevelopment, they point or poke fingers at how the meetings and all were conducted. So can you just give a short guideline in terms of how the whole meeting flow should happen and what else measures have to be taken so that the meeting is done properly? And also last question is whether general body, whatever it decides, I believe should be the rule of the law in the cooperative society, assuming they are not taking any decision which is against the law. Okay, so how do people go forward when they go for conducting of meetings?
Yeah. I would like to differentiate two eras. Definitely two eras, I would say. I will use this word: prior to COVID and after COVID. Prior to COVID, online meetings were not day-to-day business for common people like us. Online meetings were used by some corporate events, corporate persons, or the IT persons, or some the government officers, etc. We were just having the either WhatsApp call or video call for our friends and family, etc. But after the COVID period, the government has specifically issued directions to avoid the assimilation of the people physically, that societies can conduct the online meetings. Only thing is that the recording should be there as an evidence. Prior to that, the physical meetings was only the concept in everyone's mind. So let me take you first how the meeting should be conducted. For special general body meeting, the notice agenda should be issued by 7 days clear notice. 7 days means calendar 7 days. It has to be issued 8 days before. So it would be clear by the dates. If it is annual general body meeting, it has to be issued 14 days prior to the meeting.
Sir, clear, does it mean Sundays also?
Yeah, Sundays also. Because nowhere in the
It has part of 7.
pardon?
7 Sundays are also counted. So it's not that.
Yeah, Sundays are also counted. The public holidays are also counted, because nowhere in the act or rules or bylaws it is mentioned that Sundays or the public holidays should be excluded from these notice period. So Sunday can be counted, the public holidays can be counted, the festival season can also be counted, definitely. After issuance of those notice, it is now as we are having new technology in our hand like WhatsApp or email or some other apps also, X, like you can also, the societies can also issue the notices also. I'm saying again, also issue the notices of those general body meetings on WhatsApp. That can be a proof that the person or the member concerned has seen, read the notice agenda. The electronic evidence is also permissible as of dates. But eventually, as per the society's precedent, the society should either affix the notice agenda on the notice board or should send the notice agenda in hard copy to each and every member and get their acknowledgement either by post or by hand delivery. It is every time it is utmost essential thing. Then after conducting those meetings, the attendance register is also important. Who are going to attend and who is not attending the meeting. Third one, the discussion which is being taken place for each and every subject should be recorded clearly. A person mentions XYZ thing, that another person mentions ABC thing, etc., 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 and after finally what the resolution has been passed by the general body and who has proposed the same and who has seconded the same, and what is the result and how much majority, by how much majority the resolution has been passed. All these things are mandatory in respect of passing of any resolution. As you rightly said, whether the decision taken by the general body is final, yes. Society is the supreme authority. There is a judgment of Venus Cooperative Housing Society, the landmark judgment. Honorable High Court has specifically mentioned that the general body is the supreme authority in respect of the society working. Whatever decision the general body has taken is binding on each and every member, irrespective of the fact that he is having opposite vote in respect of that resolution, or he has not even attended the meeting. He has to follow the bylaw, follow the resolution which has been passed in that meeting. But at the same time, that judgment also mentioned that general body should not be harsh. Anyway, that is apart, that is different subject. Third, you asked me about the online meeting or how the meetings could be arranged. As I said in the beginning, online meetings were allowed by the state government. The online meetings only were allowed the state government in 2020 and for some time of 2021 also. But now, as a matter of practice, many societies wherein there are senior citizens or the members are residing outside the society vicinity, say in the same city only, or in say another state or in another country might be, they can even participate and take part in the meeting by online meeting. The meeting can be hybrid also, the physical as well as the online meeting. But please make a point that such online meetings should be recorded for the purposes of evidence. There is no provision in law, there is no circular by the government, there is no judgment of any of the court that hybrid meeting is not legal. Therefore, in other words, the hybrid meeting is legal. So the societies can very well arrange for hybrid meetings and conduct the online meetings, conduct the general body meetings by hybrid mode, and go ahead with the situation.
Okay. So sir, there are, I mean, I'm sure there are a lot of questions, but I think for the first webinar, we will restrict to one last question. Is that society needs a lot of from senior lawyers, senior architects and all. So we would like to finally ask in terms of what all services do you as a lawyer provide? If somebody wants guidance from you, how can they approach you?
For that purpose, let me take your a few minutes more. In the questionnaire you have given, what is the basic criteria that society can go ahead with the redevelopment? So the society, if the society is having conveyance in its name and its name has been recorded in the revenue records, the society is owner of the entire property and society can go for redevelopment. When society thinks and decides to go for redevelopment, I generally offer my services for the society to check their documents, their titles, title of member of the society. Further, the attending of the meetings, either the general body meetings or meetings with the builder, etc. Further, the checking of the drafts of MOU, various correspondences, and finally the development agreement. All these types of services I generally offer to the societies as well as to the developers also.
Yes, sir. So I think that was really helpful, and we will also have a platform where we will be putting across your profile also in case somebody wants to approach and discuss the they can really approach it. So sir, thanks a lot for taking out time. I'm sure redevelopment questions never see an end. There are a lot of questions which comes, and I think when we work with 10 societies, the 11th society gives a new problem.
You said it.
Yeah. So as and when we get more questions, we will also approach you again for a webinar, maybe a short webinar for particular related questions, so that the citizens in general can benefit from the webinar. So
Sure.
thanks a lot, sir, for taking out time again. And we will publish this very, very soon. And this will be, I'm sure, will be liked by a lot of people who are approaching redevelopment, or who are stuck in redevelopment, or who are thinking redevelopment.
Thank you. Thank you very much. Good day.